Okay, that was a test to see if the microphone's working, which it is. Can I, as a further test, just check, can everyone hear me? Good, excellent. Well, I'm going to speak for not 20 minutes as per the agenda, unless you really want me just to drone on for the sake of it. It's going to be rather shorter than that, so we can then get stuck into the panel sessions. It's a pleasure to welcome so many people, both in person and online, to today's discussion concerning litigation funding. As you will all know, the Civil Justice Council was commissioned by the Lord Chancellor in spring 2024 to provide advice on litigation funding. This followed the Supreme Court's decision in PACCAR. As we all know, that called into question the validity of a large number of third-party litigation funding agreements, particularly those that funded collective proceedings in the Competition Appeal Tribunal. When the CJC was commissioned, the government intended to legislate through the Litigation Funding Agreements Enforceability Bill 2024 to return the legal position concerning such funding to what it had been believed to be prior to the Supreme Court's decision. As we all know, the general election intervened and the new government decided that rather than legislate at that time, it would wait until the CJC had reported and would then consider what legislation might be necessary. Some questions have arisen about the scope of this CJC's terms of reference insofar as it relates to the PACCAR decision. The terms of reference require the CJC to, quote, explore whether the current arrangements for TPF deliver effective access to justice and identify possible alternatives and limitations, end quote. This requires us to consider the nature of third-party litigation funding. Necessarily, this requires us to consider if it is a form of damages-based agreement or should be regulated as such. Thus, one of the consultation questions specifically asks for views on the current regulatory framework and whether it operates sufficiently to regulate third-party litigation funding. That current regulatory framework is not just the current self-regulatory approach, but also that which is set by PACCAR, that is to say, the damages-based regulation framework. If the 2024 bill had been enacted, we would have had to consider exactly the same issues. It also requires us to consider whether, for instance, third-party litigation funding should be regulated as a form of conditional fee agreement, whether it should continue to be subject to self-regulation, to be made subject to statutory regulation, and if so, how and by whom should it be regulated. As the terms of reference put it, we are required to provide advice, quote, as to whether and how and if required by whom TPF should be regulated, end quote. We are asked to look at the issue broadly. Now, in doing so, there are several conclusions we might reach. We might conclude that the position post-PACCAR requires no legislation or rule changes. We might conclude that there are several other different possibilities. We might conclude that third-party litigation should be reviewed as a damages-based agreement, but the position should only apply to post-PACCAR agreements, and that any agreements entered into pre-PACCAR should not be understood to be damages-based agreements. We might conclude that third-party litigation funding ought not to be understood as a form of damages-based agreement. We might then conclude it should continue to be subject to self-regulation, or that it needs to be subject to a form of statutory regulation, and so on. We will consider all consultation responses when forming any recommendations, and we are grateful to those who have already or are planning to respond to our open consultation before it closes at 11:59 p.m. on Monday the 3rd of March. That's next Monday. The essential point is that the CJC are to consider the issues raised in the terms of reference broadly so that the government can, as it has indicated, again quote, take a more comprehensive view of any legislation to address issues in the round once the CJC's review is concluded, end quote. The Lord Chancellor did not just seek advice on third-party litigation funding. Our terms of reference also require us to provide advice on how third-party litigation funding should, quote, best be deployed relative to other sources of funding, end quote. Advice was and is also sought on a range of other private forms of litigation funding, not least those that form the focus of today's discussion: legal expenses insurance, conditional fee agreements, and damages-based agreements. We are particularly interested in considering views on whether any reforms are needed to these funding mechanisms to improve access to justice. Do, for instance, we need to reform our approach to legal expenses insurance to promote its use or to make it mandatory for some or all types of civil dispute? Do we need to reform the regulatory regime for conditional or damages-based agreements so as to make them more effective a means of securing access to justice? And if so, and in what ways? Should the separate regulatory regimes for CFAs and DBAs be replaced by a single regulatory regime applicable to all forms of contingent funding agreement? And what is the optimum relationship between these forms of funding and third-party litigation funding? In all of this, we are concerned to ensure that our recommendations are best able to promote effective access to justice for both claimants and defendants. I look forward, together with my co-chair, John Sarabji, to today's discussion. I told you I wouldn't take the full 20 minutes. That means we can get cracking, and that is what we will now do. But thank you all again.
Hopefully it's working. There we go. And I actually hadn't pressed it twice. So there we go. Thank you all very much. So the first panel today is going to look at conditional fee agreements and damages-based agreements. We have three panelists. First of all, furthest from me, Mark Friston, who is representing the Bar Council and also is a costs expert of quite some renown. Then we have Jennifer Morrissey, who is from Harcus Parker, representing the Law Society. And then we have Paul Wainwright from Clyde & Co., who is here representing Foyle. I think he's representing Foyle. Yeah. Yes. Okay. So I'm not going to say anything further. Let's get straight into it. Mark, if we could turn to you.
Thank you very much. Well, I'm going to briefly talk for 5 minutes about funding options. Now, 30 years ago, it was so refreshingly simple. 30 years ago, you either had legal aid, you qualified for legal aid, or you had before the event insurance. If you didn't have either of those two things, then you had to pay privately. So it was all very, very easy. And advising clients and dealing with matters was very straightforward. Then things changed with the introduction of CFAs in about 1995, but the real changes took place in 2000 when recoverable success fees and after the event premiums became introduced and dominated the market. Now, it's important just to recognise that that, in effect, was a form of litigation funding. It was money flowing into the legal services industries that otherwise would not have entered that industry. Now, it wasn't as a result of willing investment, it was as a result of defendants paying under compulsion, but it was a form of funding. Now, this inevitably led to an increase in costs, and this led to the Jackson Review and Lord Justice Jackson famously commenting that there was too much money swirling around the system, at least insofar as personal injury was concerned. So in 2013, following the Jackson Review, things changed, and we have the system we have today, when Quox was introduced, success fees and AT premiums became irrecoverable, and damages-based agreements became lawful. But it's important also to recognise that quietly in the background, during all that time, the early 2000s and 2010s, litigation funding stopped being champetous and became both tolerated and available, and was provided to clients on that basis. So, if you have a claim today, how could that claim be funded? Well, there are many options, and I'm afraid that consumers tend to get the short end of the stick here because there are fewer options for consumers than there are for commercial enterprises. Firstly, we must not forget about before the event insurance, but let's just assume for the moment that's not available. I think that Rocco will be speaking about that a little later on. There is, of course, the option to pay privately, but again, let's just put that to one side and assume that the client in question doesn't have the relevant funds. Then we come to old Scott Styles conditional fee agreements, namely no-win, no-fee agreements. And these still exist, and they can, of course, be combined with litigation funding, but generally only in larger claims or possibly claims not involving consumers. But you certainly can combine old-style CFAs with litigation funding. But then we come to the more interesting issue of the newer types of conditional fee agreements. So we have CFA lights, those are eat what you kill agreements, or discounted conditional fee agreements, those are no-win, low-fee agreements, and the flavour of the month, Harrington agreements. Now, perhaps I should explain what a Harrington agreement is. That's a conditional fee agreement, joined in almost any contract of retainer, where the damages are ring-fenced. So with a Harrington conditional fee agreement, for example, if you win, the lawyer will get to keep any recovered costs, but may deduct the shortfall only up to a percentage of the damages. So the part of the damages are ring-fenced. Now, these are very popular at the moment because they can be adapted to almost any type of commercial situation, or the needs-only commercial situation. So we have all these newer types of conditional fee agreement. And then we have damages-based agreements. Now, these differ from Harrington agreements because the lawyer is entitled to a share of the damages as opposed to limited by a share of the damages. But they're a singularly unpopular choice, and this is because of their well-publicised drawbacks. So by way of example, the lawyer is, for all practical purposes, not allowed to keep any recovered costs, and this would be so even if the reasonable costs would far exceed the percentage payment. And also the limits on the monies that the lawyer could charge in a personal injury claim, for example, are so restrictive that no lawyer could possibly make a reasonable profit. And of course, then we have all the problems concerning the technical issues and PACAR and so on, and everyone in this room would know all about that, so I won't go into that. So there are many options. We've got BT funding, we've got private funding, we've got new and old-style CFAs and damages-based agreements as well. Sad to see that legal aid isn't on that list, but we are where we are. Now, it's important to realise that perhaps the biggest change in contracts of retainer in recent years has been that they no longer are limited to dealing with the remuneration of the lawyer. Now, why do I say this? Well, in just the way that do you remember I said that traditional litigation funding had quietly been establishing itself in the 2000s and the 2010s, almost under the radar? Well, the same has been happening with business-to-business funding during the 2010s, and that's where the lawyer, during the 2020s, and that's where the lawyer pays for the funding, but this is, of course, then financed by higher fees to the client. And indeed, it's now not uncommon for clients to be offered what I call package holiday retainers, where not only is the funding incorporated within the contract of retainer in the way that I've just described, but so is an indemnity for costs. all paid for out of the lawyer's own fees. Now, we've got to recognise these types of contracts exist. They potentially have many benefits, but they've certainly made matters more complicated. And they can also lead to real problems when things go wrong, for example, if the firm becomes insolvent. So all of this means that explaining things to clients can be much more challenging task than previously used to be. And I think that's something that Paul will be talking about a little later on. So what are the options in terms of regulation? Well, the first option is masterly inactivity. If it ain't broke, don't fix it. One could say, for example, that the market has adapted to the present regime and is working fine. So why not just leave it alone? That's the first option, masterly inactivity. The second is selective activity. Here, one could update either the CFA regime or the DBA regime, or possibly both, but independently. And here, looking at the CFA regime as an example, one could ask if the regulations drafted in the early 2010s continue to be fit for purposes in the world we have now. So taking Harrington agreements as an example, say very, very common, especially in the consumer space, really what the client wants to know, all they want to know, is what do I pay if I lose and what do I pay if I win? And that's really the Harrington limit, the percentage that can be taken from the damages. But that's entirely unmentioned and certainly unregulated at the moment. Is that something that perhaps we should be looking at? And what of these package holidays agreements as well? Do they deserve closer scrutiny? Are they good value? And do they provide enough protection for clients, especially in the event of insolvency? So there are all sorts of questions there that we could look at under the second option, which is selective activity. And then there's the third option, which is combined activity, this being where the CFA regulations and the DBA regulations, and possibly others as well, could be amended in a coordinated way, possibly resulting in a combined regime. But I'll say no more about that because I think that Jennifer will be dealing with that or touching on that in a moment. So for the purpose of today, the purpose today is to stimulate debate. But before I finish, I want to finish by saying one final thing, and that is that Parliament does not have a great track record for legislating in this area. Many people in this room will remember the cost wars of the early 2000s. I certainly do, because I bought my first house as a result. But more recently, people will remember PACAR and so on, and there are many, many, many other instances. So lawmakers in this area must recognise that making regulations is difficult. It really is difficult. So perhaps we ought to be thinking as well about not only about what we regulate, but about how we regulate. Is it, for example, a good idea to police compliance by way of making non-compliant retainers unenforceable? Or has the time come for a more nuanced approach, perhaps that akin to that which is used in consumer credit? I don't know, but it's worth thinking about. Well, I've said quite enough. Thank you very much.
Thank you to Mark for that helpful history of where we are. I mean, I think it's pretty hard to follow the encyclopedia that is Friston on costs, but I'm going to do my best. As Mark said, there are a number of options on the table. The do-nothing option, the amend and improve what it is that we have, or almost start from scratch and tear it all up and have a combined contingency fee regime. Obviously, the purpose of today is to hear your views, but if I may make a few comments. And leading from Mr. Justice Picken's introduction, I was thinking that I must clarify that I'm approaching this part of the panel thinking about it almost from the traditional or the pre-PACAR approach to DBAs, i.e. thinking about contingency fee arrangements between solicitor, counsel and clients, rather than thinking about funders and whether or not they're agreements for DBAs. So there hasn't been any legislative change in 12 years since the DBA regulations were introduced. Since they were introduced, the DBAs have been considered problematic and not fit for purpose, and the uptake by the legal profession has been limited as a consequence. And this basically undermines the reason why DBAs in particular were introduced, i.e. to facilitate access to justice and extend ways in which legal claims can be funded, and also to offset some of the changes to the CFA regime, for example, the irrecoverability of success fees and ATE premiums. So pausing there, if uptake has not been as high as it could be and practitioners have identified significant problems, with the regime, then doing nothing doesn't seem to be the most effective solution if we want to meet the aims of what contingency fees were introduced for, i.e. facilitating access to justice. There have, of course, been attempts to reform the DBA regs. There was a CJC consultation, I think in 2013 or 2014, and even draft legislation produced in 2019 by Nick Bacon, KC, and Professor Rachel Mulholland. So this is not something new. The proposed changes in 2019 sought to fix a number of the problems with the regime, DBA regime. Firstly, moving from the Ontario model to the cost recovery success fee model. That is that recoverable costs in addition to success fees could be paid to lawyers. And at the moment, as Mark said, they're offset. So this would be particularly beneficial in low-value cases and better facilitate access to justice where you're talking about much smaller pots of money than some of these big claims that you hear about in the Competition Appeal Tribunal. Secondly, it would allow the DBA percentages to be applied to any financial benefit, not just to sums recovered, which is one of the quirks of the current regulations. The advantage of doing something like that would be that they could be used in a wider variety of cases, including where there's diverse assets, and also by defendants, where there would be a financial benefit to a defendant could be avoiding paying out on a liability. And thirdly, there were issues identified with early termination in circumstances where a client had, for example, acted unreasonably, and they were proposing changes to allow lawyers to seek partial payment of their fees, the sort of so-called hybrid DBA model. So these are all good ideas, none of which have been implemented several years down the line. So I think these proposals ought to be reconsidered so that DBAs could become fit for purpose. Whether that's in a combined regime may be something that we'll come on to discuss with you all later. But I think just with a few final other comments, I think this is again picking up on something that Mark said. If you're entering into a contingency arrangement with clients, you're almost certainly likely to have quite a complex set of client engagement documents explaining how the contingency arrangements work and why the percentage figures or the success fees have been set in a particular way, in addition to all your kind of usual client care obligations, as well as all the consumer legislation that comes into it about your cancellation notices, your GDPR notices. You can end up with client engagement packs of 30 pages of more, and that is just not client friendly. As Mark said, what clients really want to know is how much am I going to pay? If I win, how much am I going to pay if I lose? They don't want to trudge through pages and pages of client engagement documents to find the answer. So I think the contingency fee regime does need to be simplified. Maybe a single contingency fee regime is the answer, as long as it's simple. Remembering if its purpose is facilitate access to justice, then any draftsman or women need to remember who is going to be using them. And finally, I suppose I don't want to be thought that I'm saying the entire contingency fee regime is ineffective. We all use CFAs and DBAs with clients all the time, and it has encouraged clients and lawyers to properly sit down and assess the risk of taking on a case at the beginning, and arguably does focus both claimants and lawyers' minds on the merits prior to commencing proceedings, particularly if there are fees at stake. And I think their introduction is a good thing for the legal system overall, but there is room for much improvement to ensure that we are facilitating access to justice and helping clients. I look forward to hearing more of your views later.
Thank you. I'm Paul Wainwright. I'm a partner at Clyde & Co. And I manage the costs and funding team globally. I work closely with our internal risk and new business team, both in the UK and internationally. One of my roles is to work with clients to consider their funding options, including third-party funding, assess risk, and ultimately ensure all retainers we enter into comply with overarching regulations, and crucially, most crucially of all, are clearly explained and understood. We mainly engage with institutional defendants and large corporates, but we do represent individuals in a wide range of litigation. Ultimately, and slightly sadly, that means I've spent an inordinate amount of time reading the Solicitors Act and related funding legislation over the years, but it has made me feel slightly better about turning 40 last summer to hear the 51-year-old Solicitors Act recently described as a relic, because that means I've got 11 years until I'm described as one. I'm not here on this panel just to be contrary, but whilst I agree that the Solicitors Act, and particularly Section 70, does not practically reflect modern legal practice, and particularly so with contingent funding models, I think significant caution should be adopted before there is any further wholesale reform for three principal reasons. Plainly, the Solicitors Act is not stifling legal practice in any practical way. Generally, solicitors' practices are reasonably buoyant and robust in most areas, and I don't think it's accurate to say users of legal services, whether they're companies or individual consumers, cannot engage lawyers on agreeable terms. The overall level of legal costs may be problematic and a barrier to access to justice, but the wide range of funding options and the relevant and differing regulations covering CFAs, DBAs, etc., give consumers of legal services choice and protection, and increasingly allow lawyers to be creative and, when required, have some skin in the game. It's entirely fair to say that LASPO and the current DBA regulations sit uneasily with the Solicitors Act, and there are obvious continuing issues such as interim billing under CFAs and Section 70 protection. The form and content of bills rendered to clients, and particularly the lack of detail required in non-contentious matters, does need to be clarified. And inevitably, the multiplicity of regulation does create additional friction. But it's also true to say that the Solicitors Act does coexist with the additional regulation, and CFAs and DBAs now in particular are becoming more widely used across more claim types as well. And judgments such as Zubri and Ton State have clarified obvious issues with the current regime and increased the proportion of claims funded by pure or latterly hybrid DBAs. My second, slightly more controversial point is that some of the calls for reform are in part driven by solicitors being the author of their own misfortune and ending up in cases before the various courts, whether in contingent or traditionally funded matters, because of imprecise, inaccurate and generally poor quality drafting of retainers, agreement and bills which aren't properly understood by the clients. And it creates many of the practical problems we see in the press. This is a small category of cases, but they're high profile, and it attracts wide attention, and it contributes to the drumbeat of reform. So my usual first stage of preparation for any hearing or seminar is to look through Westlaw. I mean, other legal reference sites are available. And I searched DBA, CFA and legal billing, and the number of cases that came up with courts looking at the incorrect form of interim statute bills is surprising. Cost Judge Whalen said recently, and which I agree with, a solicitor-client retainer requires or should at least invoke the application of straightforward legal drafting. Any relevant uncertainties, twists or pitfalls have been considered exhaustively in the contemporary jurisprudence. There is no real excuse for imprecision, uncertainty or ambiguity. I don't think that's an unreasonable view, and I think that it's also worth flagging that the calls for reform grew exponentially when certain firms sought to make a business out of challenging solicitors' invoices, mainly in personal injury claims in the post-April 2013 LASPO CFAs. This practice, of course, has been significantly curtailed by the Court of Appeal in Belsner, and my rhetorical question is, would the calls for reform be so loud if this practice and business model hadn't developed in the first place? And if the answer to that is yes, does the Court of Appeal, the fact that the Court of Appeal robustly dealt with it, perhaps suggests that reform isn't as urgent? My final point, as Mark said, is reform can be problematic and shouldn't be entered into lightly. And the cost wars and the DBA regulations I mentioned a few years ago. I mean, the DBA regulations took 9 years for the jurisprudence to answer some of the profession's questions as to whether they were viable or not. Reform to the Solicitors Act, even for contingent-only cases or reform of contingent-only cases, could be even more wide-ranging, and many hundreds of thousands of matters could be impacted negatively if the rules are unclear, and bluntly, we could end up with a Belsner round 2 times 100. Reform could, of course, fix many of the remaining issues, provide simplicity and clarity to consumers of legal services, and certainty to solicitors. But my view is that wholesale changes need to be very carefully considered against the risks. Sir Geoffrey Voss recently said that the balance between the protection of consumers on the one hand and certainty on the other needs to be re-evaluated in order to produce a system fit for the current century. My question is how and what practical measures need to be taken. Standard wording and form for all bills, interim statute bills becoming a relic of the past, an entirely separate set of rules for contingent funding arrangements with specific rules for things like interim payments under CFAs and DBAs, and a standard form for any deductions from damages, standard timescales for challenging solicitors' bills, it goes on. All of this could be entirely sensible, but I suspect there will be significant opposition for and against some of the possibilities. And my open question is, do the well-known issues with the Solicitors Act and contingent fee arrangements generally justify wide-ranging reform, given that solicitors are adaptable and continue to operate successfully under the existing, albeit 51-year-old rules?
Thank you very much, each of the three of you. Food for thought. So with that, do we have any questions in the room? Yes.
Sorry, Katie Manley, Professional Negligence Lawyers Association. Just to say thank you all to the working group. This is obviously going to be an extremely challenging and much more widely focused consultation than I suspect that you took on with PACCAR. It obviously says in the terms of reference that it has expanded really to be advising the Labour government about general reform and possibly reopening a lot of questions that were we thought possibly were answered by Lord Justice Jackson and the reforms and LASBO. In a lot of ways, I'm very hopeful and excited about that opportunity, and would perhaps first say that one of the things that I would like to ask the panel to do, and everyone involved, is instead of looking at this as simply an academic exercise, but to pick up on what Mark and Jennifer said, to think of yourselves as having a claim. And there is not going to be a consultation response for representing the claimants and the clients as a group. And I don't know if you've got a picture in your head of your typical claimant, but I've been a solicitor for 30 years. I also man the Professional Negligence Lawyers Association helpline and have done for the last 20 years. And I can assure you that claimants come in all sorts of age, shape, size, background. As one example, I had an expert not long ago, structural engineer, who claimed to have been acting for Lord Justice Jackson himself. And offered him as a reference. Now, if litigation, personal litigation can happen to him, it can happen to any of us. And if it's not going to happen to you personally, or you really don't think it's ever going to happen to you personally, what about your families? What about your friends? There are social situations, whether it's Christmas lunch or down the pub. If it hasn't happened already, I think it probably does happen frequently to a lot of us in practice, that from time to time, you get approached with someone who's desperately worried with a problem. And the process at the moment that has to be followed, Jennifer's touched on it, these mounds of long and complicated paperwork. And as Mark has rightly said, the options potentially available on funding are only the beginning. It moves on then to every solicitor having to decide whether they can act. And I can assure you, since LASBO, a great many people have an initial conversation with whether it's me, or we've got 334 members at the moment of the PNLA, whether it's one of our members or other solicitors up and down the country, a lot of them are being turned away. And the proportion who will have that initial conversation, and it probably goes no further, is greatly higher now than it was before LASBO, which in some ways is unsurprising. The Wolf reforms were stated to be a replacement for legal aid. And as Mark's rightly said, I remember in my early career, you had green forms that were pretty much eligible for everyone. The introduction of CFA with success fees, I have to say, certainly from Hailsham Chambers, not everybody jumped on the bandwagon. I know one or two barristers who I've worked with at Hailsham Chambers who do CFAs, but a lot of your chambers never have. And that's, so the sort of whole question of access to justice depends on people like the barristers at Hailsham or other barristers being willing to do any form of no-win, no-fee type funding. And it's the same with solicitors. I mean, my first CFA was actually with Patrick Lawrence, who you may remember. He was at Hailsham at the time in the, around 2020, around 2000. But there's a lot of solicitors I speak to who, as a matter of principle, won't do them, and they won't do them because they're uncertain, because of the time involved. Often you take on an innocuous case and it could end up taking up most of a fee earner's time for the next few years. You have to kind of factor that in. There's an uncertainty as to how much in cash flow terms it's going to cost the firm. But the nightmare scenario is the one that you've all been referring about to, which is that it ends up being one of those cases that Mark was talking about, where it's challenged in some way, whether it's the drafting of the retainer, whether it's compliant with the CFA or DBA regulations. And that's, so of those small group who really want to help the deserving, really want to help people win their cases when they're in ghastly and tragic situations, and most solicitors do, most litigators really do want to help people out there. The barriers that have been put in the way, whether it's through uncertainty, complexity, are almost impossible after LASBO under a certain value. That's what we've put in a consultation response, and you can see a number of our members' views on what that value is. But post LASBO, we're probably talking about claims under 150,000 being impossible to fund on an arithmetical calculation basis, looking at cost, risk, benefit. Before LASBO, it was possible to run a strong claim even at a much lower value. So those are sort of points I would say approach it as if it's you or you're a member of your family. And if you can come up with a solution to the funding regime which makes it easier and more attractive to lawyers and your colleagues to do them, I think that would be a fantastic result.
Thank you very much. Mark, do you want to?
Do you mind if I just pick up on 2 points there, really just to ask for people's views? One theme that is developing here is the complexity of contracts and the length of some of the packages that have to be produced. And that's particularly the case when you're talking about consumer clients. Do people think that the requirements to comply with those cancellation regulations and all of the requirements to give information, because we have a great long list of them, do they think that helps, or do they think that perhaps that's getting in the way? Does anybody have any views on that? At the back.
David Green, and I was on the Rules Committee for the original Wolf reforms.
Yeah.
Time in this business. I'm not quite sure what you mean. I mean, I think the problem for CFAs, which actually work quite well, DBAs don't, but CFAs do. I think the difficulty is, as you identify, is all the paperwork that goes with it, which sometimes solicitors get wrong, for one thing, but secondly is that it's long and complex documents that the client doesn't necessarily understand, and to some extent don't assist. So I think reducing the complexity of the process of CFAs, I think is a goal to be aimed at, make the whole process much easier. I think for DBAs, and we just don't use them. And of course, Jackson, Rupert, suggested, he was very much a promoter of DBAs, But if one thinks back to Wolf and the practicalities of change, the Wolf reforms, really the politics behind the Wolf reforms was cuts in legal aid. And there were cuts in legal aid on personal injury at the time, which gave it some force. And I think also Rupert's reforms were also accompanied by cuts in legal aid, so that you get government interest in that. I think the practical problem, as someone has identified, is getting government interest in civil justice to make the changes. In DBA regulations, the Civil Justice Council, I was on the first committee with Rachel and Nick, and we made recommendations, and then we had another CJC report on recommendations, a little more fulsome, a little more detailed from Rachel, but never got any purchase with the government. The MOJ just with all respect to the MOJ, just didn't seem to have an interest in it. And I wonder what actually is practically achievable in relation to DBAs and CFAs. As I say, I think the CFA regime works quite well, and we use it a lot, but we don't use the DBA regime. And I wonder if we could just have another go at the DBA regime, try and get that right as just a small aim in order to achieve some changes for access to justice, particularly on this subject. I should express a wider concern that I have on practicalities is that these discussions start with PACCAR, and I do have a slight concern that we're going to lose within the wider picture because of the substantial changes that the Council might suggest. We're going to lose the main aim, or rather where this has started, which is in relation to funding and PACCAR. And I would, what we had was a very simple bill introduced in the Lords, simply to undo PACCAR, or however one puts it. It got support in the Lords, and would have got support, I think, in the Commons, and would have been passed, but for the wash-up issues. And I do have a slight concern, is that in looking at the whole picture of funding and its practicalities and getting change, I think there is a danger that we slightly lose the focus of how this started, PACCAR. And I must say I would like to see out of the Council's recommendations in due course something quite concentrated to ensure that we can try and get some government support for this, which, as I say, is very difficult, and the Labour government's got a lot on its plate. It's not going to go to civil justice quickly, and I do ask that we look at the practicalities of ensuring that we have focused recommendations that really we have some hope of a government putting into effect.
Does anybody want to respond? Jennifer?
I was going to say, I agree, David. I think there were issues with the regime. Can you hear me? Sorry. There were issues with the contingency fee regime before PACCAR, so you've kind of got to deal with that, as well as the issues arising out of PACCAR, was the only kind of comment that I was going to make.
Julian Chamberlain, Risk and Funding Partner. Stuart's really just to jump on exactly the same points, David. I think you've nailed it on both fronts. By and large, the CFA regime works. It's not perfect. You could tinker with it, but there are dangers with tinkering it. The DBA regime largely doesn't work, hasn't been taken up by the majority of solicitors. There are a rare few who, in certain very limited circumstances, will do DBAs, but hasn't broadly been taken out, so isn't proving very effective access to justice, albeit conceptually having been a pretty good idea and a very client-friendly idea, because as you say, Mark, really clients want very simple agreements that tell them how much they're going to have to pay, and at its core, DBAs do just that. So we had those recommendations from Nick Bacon and Rachel Mulherron in 2019. Even those weren't particularly new. They were issues we'd all been debating for years. That was good to go, largely speaking. There was a piece of amended regulation ready to go. It's still ready to go. Again, it probably could be nuanced with a few things we've learnt along the way since then. But absolutely, I agree with David. If the panel could really focus on that aspect and also dealing with PACCAR, those are two things that would make a difference, and by and large the hard work's already been done. There are a really interesting wide range of other topics within the scope of this consultation, but there is a serious danger. They are so wide-ranging, we could spend the next 5 or 10 years talking about them and not actually resolve those two fundamental underlying points.
Thank you very much. The gentleman at the back, and then we'll come to the front.
Hello, Adrian Chopin, founder and managing director of Benchmark Advisors, litigation funder. We've talked a little bit about DBAs, and we've talked a little bit about PACCAR. I've not ever heard a principled reason why DBAs cannot be used in the CAT for opt-out claims. It seems to me that it was the result of some messy lobbying, but it doesn't really matter why we are where we are. I think it would be helpful that the council consider tolerating DBAs in opt-out claims, not least of all because it would be a workaround for PACCAR. So it would solve an unprincipled blocker and also solve in a slightly messy way a PACCAR problem.
Thank you. Thank you. The gentleman.
Thank you. My name's Jamie Malloy. I'm head of AT at Ignite Specialty Risk, which is in quite a distinct position to other insurers in the market in that we underwrite the big ticket work, the CAT work, which Adrian's alluded to, and then also the mass consumer work seen in the county courts up and down the country, and then the middle work, as it were, the claims that Katie was alluding to, which are maybe valued between £100,000 to £2 million. I think that what we just wanted to impress upon the panel and will submit as part of a wider submission is that when Jackson reviewed civil litigation back in 2008 through to 2010, he had significant criticisms of costs in injury claims and partly privacy litigation. But he wasn't broadly critical of how CFAs operated in wider civil litigation. And I think there's wide consensus. There's a sledgehammer to crack a nut with the abolishing of CFA uplifts and recoverable ATE. What we've seen in practice as a result of that in the 10, 12 subsequent years is that the people that Katie alluded to aren't getting access to justice because it's not in the law firm's interest to engage in CFAs because of the lack of recoverable uplift. There's numerous partners that I'll speak to within law firms who can't convince their partners, the finance team, to run 100% CFAs because there just isn't that risk reward anymore. So whilst I do take on board the various comments that we don't want to lose sight of the primary purpose of this, I do think it's an ample opportunity to revisit Jackson, look at the case studies of people who aren't getting access to justice, who could get access to justice just by having a revisit of removal of Section 58, which would be to reintroduce recoverable ATE premiums and reintroduce success fees, which in turn would mitigate the use of litigation funding. So whilst litigation funding is starting to be used in smaller value cases, it's still not really available. So that then leads you on to the next point. Is there risk of abuse? And my view is that there isn't. I still think there'd still be slow take-up from law firms to engage in CFAs, but notwithstanding that slow take-up, there'd still be more access to justice. We're involved in an ongoing High Court case, which I can discuss because there's a public judgment coming out of Cardiff, where the judge went out of his way to acknowledge the work that had been done under the CFA and the ATE facility put in place by us and the law firm. But the inevitable conclusion to that claim is that we're going to have to deduct significant sums of the client's damages. Now, the factors of that case are that the claimant is a private individual. She's a widower who is suing her insurance broker for failing to advise on the coverage of the insurance policy that her husband purchased. And the only way that claim could be litigated was through the utilisation of the CFA and the ATE regime. But nonetheless, even if she does succeed eventually, she's going to have to pay us. And that can't be right. So part of the thing that we're doing at Ignite is, whilst we're backing the big ticket work, the CAT claims, etc., we're doing that in order to work completely no win, no premium on the smaller work. Not because it's profitable necessarily, but out of a sense of wider justice and what we're trying to achieve here. So I do think that there's again, without losing sight of the core purpose of today and the consultation, I do think a quick fix would be to reintroduce, subject to, obviously, wider consultation, recoverable uplifts, recoverable ATE, so that people can litigate these cases relatively risk-free, but at the same time not incurring a have-a-go mentality, because commercial law firms simply don't do that. So I think where there's been historic criticism of that methodology, it's been in the injury sector where the risk was low value. In commercial litigation, there's significant risk on every claim, so there's no guarantee that it's going to result in a win, but if law firms are winning, they should be able to charge 100% uplift, and they should be able to charge that to an opponent as opposed to deducting it from their client's damages. So it just, I mean, it should be interesting to see if there's any, particularly from the panel, any advocates against those views, or whether that's widely adopted as a consensus.
Does anybody have a view on going back before Jackson?
Well, it's really a simple question of who pays. Is it under the previous regime? As I said in my introductory talk, there was litigation funding, but it was by compulsion rather than voluntary investment by defendants. But it was litigation funding. Now the pendulum swung the other way, and if you actually look at the history of costs, you see the pendulum swings backwards and forwards about every 15 to 20 years, but the pendulum swung the other way, and clients are essentially having to, either clients or lawyers, are essentially having to provide the funding by way of litigation funding, be that business funding or client-facing funding. Which of those is right, or whether there should be a mixture of those two, is very much not a legal question. So I don't express a view as a point of law, but I do understand the points that you make, because I think it is very important that you do put yourself in the position of a client. And I'm putting myself in the position of somebody having, I don't know, wanting to sue for my fees. Could I do that? No. Or if I did, I get a tiny amount. And I think we all ought to be doing that for the purposes of considering what to do next. And that, certainly from my perspective, your encouragement that we should be putting ourselves in the position of clients has been very helpful.
Hi, Greg Callis. I'm barrister at 5RB. In media law, an area that used to have a huge amount of CFAs, I used to do a lot. They've largely dried up. I don't think anyone thinks it's because of the complexity of the CFA regime. The regime is completely fine. It's a purely economic drying up because there's no recoverability of the success fees. I should say, I mean, with the possible exception of phone hacking, I don't think anyone was ever actually making success fees on top of... The great thing about success fees was that it meant that you got topped up to essentially 100% basic. You were prepared to back your judgment. In privately paid cases, you get 100% of basic. The problem with CFAs without success fees is you got, if you didn't want to dip into your client's damages, which we often didn't, you got 70% of basic. And it seems weird to get 70% of basic when you're taking the risk on the litigation. That's why they've dried up. It's an economic matter rather than a regulatory matter. Damages-based agreements is completely the opposite. Everybody loves the economics, but nobody likes the legal regime. And I understand that there are plenty of people who want the Civil Justice Council to focus on PACAR. I slightly want to take advantage of the powerful interest in overturning PACAR to get some other things done, particularly on DBAs. I've got less of a problem with PACAR, for instance, than I do with Candy and Tonstate, because I think damages avoided based agreements, I defended DBAs as someone who does defended CFAs, I think is a huge burgeoning market that we've never had and we should have had. And that might be perhaps a slight sugaring of the pill that defendants, particularly defendant insurers, might have to take if there are other reforms that I like the sound of, like perhaps expanding opt-out so it goes beyond the CAT into other forms of class action, which might make funding of those sorts of class actions. So I don't think there's a regulatory change that's needed on CFAs. It's an economic change, perhaps in the Rules Committee. The regulatory change needed is in DBAs.
Thank you very much, Greg. We're almost out of time. There were a number of questions that came in over the internet which focused on questions of transparency within CFAs and DBAs and the way that solicitors treated their obligations in respect to transparency. I think the panel and also the questions in the room covered those in terms of simplification, making more accessible client care letters and engagement letters, etc. So hopefully that will be something that will be picked up by some of the written consultation responses as well. It's something that we will need to deal with. But thank you all very much, and thank you to the panel. We will see where we will go with CFAs and DBAs. We have a break now, and then it's back for legal expenses insurance. Thank you.
Mouse and keyboard there, so you're quite happy? You know how PowerPoint works? Yeah. I'm surprised how many people don't know how PowerPoint works. Head slide.
See, I'm the one who doesn't know how PowerPoint works.
I'll be back in a few minutes.
Thank you.
You should be all right, shouldn't you?
Yeah.
You know how to get it back full screen again.
Yeah, thank you.
Well, welcome back, everyone. So session 2, we're now turning away from CFAs and DBAs and looking at BTE insurance and to what extent that might help enhance access to justice. And we've got an excellent panel once again. And we're going to start off with Rocco Pirizzolo, known to many of you in this room, I would have thought, Managing Director and Underwriting Director at Harbour Underwriting. Been on too many of these past panels and working groups to mention. Also the author of one of the first litigation funding textbooks. Was it the first, Rocco?
Yes.
It was. There we go. Over to you, Rocco, please.
Oh, thank you very much. I should say that there's been no consultation between the panellists. We were all set the same brief, so you might hear some interesting views between us. Hopefully we're not all agreeing. So the focus is before the event insurance and how best to promote it. And the first issue really is, should the use of before the event insurance be broadened? I think the answer to that must be yes. I know that there was a concern raised in the interim report about would this promote unmeritorious claims. I don't see that. Ultimately, all before the event policies have a merits test of at least 51% prospects. So I think that's an argument that's dead in the water. How far should before the event insurance be promoted? Now, the question here is very much, in my mind, what's the objective? Now, in the interim report, there's reference to the Sweden experience, and there's also reference to the Canada suggestion. So let me just touch on the Canada suggestion, which is a mandatory legal expenses scheme to replace legal aid. Well, that I don't think is in discussion today. I think what really is being spoken about is to what extent can before the event assist as another viable funding option for the types of cases which are being funded by litigation funders. I think that's really the issue. And in fact, the interim report alludes to that because it asks for feedback on group litigation. It specifically asks about collective proceedings. I think the hint and the direction of travel is highlighted in the interim report. Obviously, any discussion about group litigation is unhelpful from a BT insurance perspective because that doesn't describe a type of case. That describes a way of presenting a case, a way of progressing it. You know, are we talking about public and private nuisance claims? Are we talking about public liability? Are we talking about diesel emission claims, all of which you'd go for a GLO? So from a BT insurer's perspective, that's unhelpful. But equally, the profile of those cases are entirely different. I think we all know product liability claims are inherently difficult to succeed in, unlike probably public and private nuisance claim, if you were to draw a comparison. Collective proceedings, well, can BT be used, if it was extended, usefully for collective proceedings? Well, if it was opt-in, it could be used in the same way as a group action. You could have a modest limit of indemnity. Now, as you'll be aware, limits of indemnity before the event insurance tend to be around 25,000 to 100,000 as a broad range. Now, if you have a group of, say, 10,000 claimants who have BTE, you can do the maths yourself. That's a sizable limit of indemnity that can then be used, half of which of that limit would be used to pay solicitors' fees and disbursements in the case, and the other half would be allocated to adverse costs. BT clearly wouldn't work for an opt-out because you have a class representative. You only have one person who would be the insured. So there's an automatic drawback there. The thinking here has to be very clear about to what extent can BT usefully step into this space. And how can, and very importantly, is distribution. As we all know, BT is distributed by and large as add-on, bundled into other insurance products. And the interim report talks of 2 experiences in other jurisdictions, always a good thing to do to look at other jurisdictions. But what happened in Sweden? Well, basically, they helped distribution of BT because the government imposed on household insurers that they had to add it in. That was government driven. Germany, again, we look at Germany. Now, I'm not so sure how great an example it is for us. First and foremost, I would say, it's a mature BT market. As the interim report says itself, there are 44 insurers who provide this type of insurance. That is definitely not the situation we have here in this country. Nowhere near that. Handful of meaningful insurers. So they are a sophisticated market. They are there operating in a competitive environment, and they have to compete. Whereas here it's entirely different. I think our market is immature by comparison, but it comes from a certain historical background. So I don't mean that to be unkind about the UK BT insurers. It's just that we've started from a different place. And of course, the interim report does also talk to some very important points, which are practical points, but they're real points. Because ultimately, any BT insurer would have to be approached to basically extend the cover, and there'd have to be a business case for that. So whatever is decided about extending the types of claims which are covered, it's inevitable there has to be a business plan and a thinking around it. Because ultimately, the BT insurer will only want to do it if they feel they're going to make an insurance profit. There's never any guarantee they will make an insurance profit. Unfortunately, no insurer can guarantee that, whatever class of insurance you write. But the intention is that you've done your due diligence and you understand basically what it could potentially look like. So if you do decide to extend cover for group actions and for opt-in collective proceedings, you've really got to do your homework on what the additional exposure is. Sadly for us, the CAT regime is not bedded in. It has uncertainty still, and that's totally understandable. It's still new in legal terms, but you can see that insurers are prudent animals. That's what that's the way they operate. They might find that a scary environment to be working in. Of course, even if they were so minded, if you have an additional exposure, it has to be priced in. It has to be priced in. So if you have an average premium for add-on, and again, the reports on this that tend to talk around £15 to £25 for add-on legal expenses, if you start adding group actions, collective proceedings, where the exposure is significant, you have to expect the premium is going to be multiplied by X. Now, I'm not in a position to talk to that. That's an actuarial exercise that pricing actuaries do. Now, the big unknown, and this is the real issue, and this is the nub of the problem, because all of what I've spoken about, you can say, well, that's due diligence, you can work on that. The big unknown is this. If you extend the cover and you do not sell it and you do not get the premiums in, your exposure is in the policy, but you haven't got the pot of premiums to pay the claims for those additional claims that you've now decided to insure. That's the big risk. That's the big unknown. Distribution is the big issue. Now, it's a huge challenge. I actually think there are glimmers of hope, insofar as in one respect only. Are there lessons to be learnt from what's already happening? We have insurers and we have employers who are employers who are providing legal helpline assistance to their employees, which cover legal disputes. They also cover counselling, stress, other type of services. It's a benefit in kind. Is it such a stretch then for asking whoever provides that to extend that type of service, that type of cover? And I say that on the back of this. We have been busy talking about other jurisdictions, and again, I caution being wary about that. But one of the things we ought to realise is that there was a time, and I don't know when this time was precisely, but the very same issue was about promoting private health insurance. Now, employers took up the cause. They now provide that as a benefit in kind. And that's provided in many companies and by many employers. Is this a way of they're opening a discussion about employers who are already providing legal helplines, some form of cover, it possibly being extended, and employers being in the position where they can afford to pay, and I'm surmising now, £100 per policy instead of 15 to 25, because it's a benefit in kind. It's one way of attracting staff, retaining staff. Still, of course, that's a way of dealing with distribution. But there has to be a conversation with the BT insurers, and this is, a big discussion point. It's a big exercise, and it might need for one of the BT insurers to break ranks because they feel they're going to get an edge over their competitors, or it might have to be a new entrant into the market. So I'm not saying it's impossible, but I think looking at these other jurisdictions, I think can be misleading, not least because zooming in on Germany, as we all know, scaled fixed costs, that's something we don't have here. When I talk about the exposure for adding different types of claims to a BT policy, this is exposure that you can't entirely measure. And that is a real issue we have in England and Wales. Thank you.
Rocco, thank you very much. And really interesting point there about BTE as a potential employee benefit in kind. We'll turn to our next speaker now, Greg Callis, barrister at 5RB, specialising in defamation, contempt of court, confidentiality, data protection, privacy, and also a contributing editor to the White Book. Over to you, Greg.
Thank you. Defamation is actually one of the few areas where there's a fairly vibrant BT market, particularly for newspapers. Being sued is very much an occupational hazard for most journalists, at least the ones who are doing their jobs properly. And if they're not covered by their insurer through the newspaper, a lot of them also benefit from legal expenses insurance through membership of their unions. I first started talking to John Sarabji about mandatory legal insurance in a slightly different context about 12 years ago. We were talking about, last we were talking about the cuts to legal aid. And it strikes me that most of the reform that we've ever had in this area has been, I think as somebody pointed out earlier, at a time when government has been thinking about cutting legal aid. In civil justice, we're in the strange situation, there's really not much civil legal aid left to cut. So it's more about we have an entirely uninsured population that doesn't have access to legal services unless they have the benefit of before the event insurance, save for those somewhat higher value claims where it's possible to get ATE insurance, which is still very common in publishing cases because we are, I think, the only area left where you can still recover your premiums from the other side. I wasn't thinking about BTE, particularly in the context of group actions and opt-out. It seems to me that those are well serviced by other forms of litigation funding, whether it's third-party funding, CFAs, DBAs. Those are more than capable of dealing with the higher value claims. But there's a certain level of lower value claim that is never going to be economically attractive to the lawyers who offer CFAs or DBAs. They're never going to be attractive unless they group together in a group action of some form to allow third-party funders to take an economic interest. So we're talking about matters, whether it's in the business property courts or personal injury, or my area, media, where the damages are very low, certainly compared to the costs. Claims that are never going to be outside of the 100, 150, 200,000 pounds, many of which take place in the county court, some which might be smaller. And a feature of these disputes is, firstly, you are seeing fewer and fewer lawyers involved in them. I think most judges would say that, just as you have started to see litigants in person now, even in the criminal courts, they've become ever more regular in the family courts. They are ubiquitous in the civil courts. And that's because people are not able to afford to have lawyers go. There are very few litigants in person who, if they had the availability of funds to pay for lawyers, would still choose to run the cases themselves. The systemic cost of that and the pressures that that puts on the legal system, on court staff, on judges, on opposing counsel to assist litigants in person who are often not versed in the ways of law, they're not versed in civil litigation, they do not particularly want to be there doing it themselves. Those burdens are becoming ever more onerous. And I think one underappreciated aspect of litigants in person becoming a sort of a predominant group within the civil courts is if you think things are burdensome at the moment, the AI generation changes everything. I've now done a couple of cases where litigants in person on the other side, perfectly correctly and never doing anything wrong, have availed themselves of the enormous benefits of Google Translate, but also of ChatGPT, of AI. They're using it to do something approximating legal research. They are able to find authorities, most of which actually exist. They are looking for points, good and bad, but without the legal training to tell the difference. Certainly not all of the points made this way are bad, but what they are is voluminous. Ordinary people who have no legal training and are not necessarily even the sorts of people who would do well as litigants in person on their own are massively emboldened and invigorated by the possibility of producing documents this way. But those documents are longer than they previously were. There are more points of law, some good, most of them bad, in those documents than ever before. Replicated across the country, civil litigation is not going to be able to cope with a huge base of its users being non-legally trained, non-regulated, and yet able to generate massive volumes of both evidence and submission for low-value disputes. There's going to come a point at which a return to a system where both parties have lawyers, and more to the point, insurers have a vested interest in reaching a commercial settlement that is proportional to the sums at stake, at least in the sorts of cases that really are about money rather than injunctive relief, is going to look like something that needs to happen. So I think there are two reasons why generalized BT of the sort that we see in perhaps Germany or Canada has massive benefits. I think there's a systemic benefit to the efficient resolution of lower value disputes than can attract CFA, DBA or third-party funding. There's a reduced sort of burden on the civil litigation system, where at the moment opposing lawyers and judges are having to carry that burden as a court staff. But there's also an access to justice point, that where people have meritorious cases, it's wrong that they are not able to bring them merely by not having access to the funds. The only way that you can make it economical in those low-value cases for people to have access to lawyers who are paid for is by having a broad-based general insurance policy. For that, you need widespread distribution. And there are two challenges in distribution. The one is making sure that the insurance is in place in the first place. You could go the route of making it mandatory. Nobody expects, the state, central government, to pick up the bill for repairing your car if it's involved in an accident. We all recognise that the appropriate way for that to be efficiently done is for everybody to have insurance. And if you want to drive, you need insurance. Similarly, if you want to be involved in property litigation, boundary disputes, you need to use the lawyers who are instructed by the insurer whose policy comes with your mortgage or with your letting agreement. It's not necessarily an outrageous imposition. I think probably the best analogy is Obamacare, mandatory health insurance in the United States. But it might be that you don't do it that way. You do it by forcing insurers to offer it. I think the Swedish example was they forced the insurers to offer it at no additional cost, which was, I can see that possibly being a sticking point. But there's a secondary problem as well, is that even if everybody has insurance in place, how many people know that they have it in place and know that it can be called upon? And I think there's probably a second piece of work there, about recognising that there is an untapped well of BTE that has already been paid for, that needs to be tapped, and people need to recognise that they should be tapping that. And I think there's probably an interesting question. I have certainly started a question about whether or not it should be a requirement that if everybody had legal insurance, if you're choosing to represent yourself, that you should indicate that you did in fact have legal insurance and that it's chosen not to, rather than it being a case that there was nothing available. Because I do think there are huge challenges to the civil justice system that are going to be thrown up in the next few years. And a return to insurance-backed litigation with lawyers on both sides, I suspect might be a boon, an economic boon that's worth paying.
Greg, thank you very much. Again, some really interesting ideas there. And turning now to our third panellist, Ray Coe, Legal Counsel at Lloyd's Market Association, with I think at least 15 years under his belt at AXA XL, in charge of legal issues relating to distribution and delegated authority, and prior to that working as a litigation lawyer and also sitting as a deputy district judge. So, Ray, over to you.
Thank you very much. Let me start by telling you a story. So the first time I ever came across legal expenses insurance was when I was an associate in a law firm, and a young, energetic partner thought, well, I can provide a solution to insurers who are having problems getting reinsurance recoveries from their reinsurers, or subrogated recoveries. Why don't I offer them a risk-free way of issuing proceedings? And so what he did was he went to his broker and he put together an ATE line slip. And a line slip is utilising one of the superpowers of the London market, syndicated risk. So, and syndicated risk is where a number of insurers take a bit of each risk. And so these insurers, they like this particular lawyer, like the cut of his jib, and thought, well, if he says it, if it's all right, job's a good one, then we'll insure it. Number of punters which went for it, 0. And, it made me think about all those great products, because I thought it was a great product, and why not? I mean, I was a loyal associate, you cut me through, and then you see the name of the firm emblazoned on me like a stick of rock. And you think about those other products which were really great, which didn't take off, like the Segway, Betamax, or the Austin Princess. And why am I talking about this? And really the point I'm making is great products don't necessarily take off. We heard from Rock earlier on, one of the questions we've been asked is, should the use of BT be broadened? Well, yes. Will it? I'm not so sure. If we're talking about what the issue is here, when I think of it from an insurance perspective, insurers are out there to make money, and we think about demand and supply. And I'm not sure, I may be misquoting Rocco, but I don't necessarily think the issue is supply. I think it's demand, because if insurers see a demand for a product which isn't there, they'll build it. It takes some time and money to do it. There's lots of regulatory hoops you've got to go through. There's scale that needs to be thought of, but it's not like Field of Dreams. It's a reverse Kevin Costner. You don't build it and they will come. It's the other way around. And so then I started thinking, well, why is there no demand? And I can only speculate on this, just as a normal punter. If I'm driving or motorcycling to work as I do in the morning, and I think about the risks involved in that journey, I think, well, my house might be burgled, house insurance, might get run over by another car, so that's motor insurance, pet might get sick, pet insurance, kids might get sick, health insurance. I might have to enforce my legal rights in the court. It doesn't really figure quite highly in that list of risks. And add to that kind of lack of urgency, you've got this this unawareness of what BT insurance is. I was talking to some of you in the audience earlier on. I had no idea there was BT cover in my home insurance until I started looking at this consultation. And I wish I'd known about it before I sued my plumber. If we think about it from an SME perspective, we go through that same list. Box on the floor, employee trips over it, that's employer's liability. Public trips over that box, public liability. Business interruption if the place burns down. Intriguingly, cyber's quite a big one. And I read a statistic the other day which said that 49% of SMEs have been hacked, but only 15% of cyber insurance. If they're not buying cyber, which is a clear and present danger, what hope have we to persuade them to buy BTE? There was another question which was, absent mandatory insurance, and I'll come to that in a second. What can we do to expand the use of BTE? Well, and I can talk from my own market, which is the Lloyd's market, a specialist market. We do a lot of big stuff, but it's intermediated, which means we rely on brokers, people like Rocco, to speak to the client, bearing in mind that brokers act on behalf of the clients, not on behalf of insurers. Cover holders are a bit different, managing general agents, and I believe you're a managing general agent, so you act on behalf of insurers in that respect. But one of the roles of a broker is to advise a client as to the risks that they may come across. And so there's a feedback loop there. There's kind of like working out what risks the insured might have, and then communicating that back to the insurer. And that's how that product development process starts, those discussions, certainly in my market. Other markets will differ. Turning to mandatory, the mandatory scheme of BT, I was listening with some concern when you said, Greg, about forcing insurers to provide BT insurance as they have done in Sweden. I mean, that's, for me, you've got this focus on competitiveness that the UK government is focusing on, and so I'm naturally not disposed towards that sort of regime. You would, of course, you'd say, obviously, because he represents insurers. But if we think about how that puts us as an insurance market up against international competitors, I'm not sure how you'd enforce that against international competitors who compete in this market. But then you've also got the question for me of political priorities. I mean, it's a big ask, and I'm not exactly sure what the ask is. Dear politicians, please can you consider this mandatory scheme because litigation costs? Well, what bit? It just sounds a bit glib to me. If you think about employers' liability, health and safety, there was a clear mandate for doing that. There are real problems there which can be resolved. The other things where government might get involved in but hasn't yet, for example, could be cyber insurance. There's a big systemic risk because most big companies use Amazon Web Services and Microsoft whatever, all the cloud stuff. But there's not much action going on there at the moment. I might be a bit out of date there. But my point there is, where does this come in the scheme of political priorities? Probably pretty low again. So it's rather a pessimistic picture that I paint, and these are all personally held views, of course. And I'm sure some of you may differ with better statistics than I've had access to. But that's pretty much all I had to say about that.
Great, thank you very much. So, opening up for the audience now, and in particular, I'd be really interested to hear if anyone does think a mandatory before the event legal insurance scheme is viable, and if so, how might that work? Hilary.
Hi, it's very loud. Hilary Meredith. So I am the little lawyer in David and Goliath fights. I act for the armed forces, their families and veterans. I've done that for 37 years. Of the thousands and thousands of cases I've brought, not one has had BTE. And I struggle to understand how that would work in that sort of group of litigants. I think it would be very difficult, even if they were allowed to take BT insurance out. And also, if there are different providers of BTE, how does it work when, for example, I've just settled a massive group claim. It wasn't a group as such, every case turned on its own facts, but it was all relevant to one case. If you have lots of BTE insurers, how do they then, on a group case like that, where each turns on its own facts, decide whether they're going to join and provide BTE for that litigation? Do you understand what I mean? I'm not explaining that very well. No.
I think that is an interesting question, but the question, when you said not one of them has BT insurance, I think that is the point I'm trying to make, because you had to buy the stuff before it happens, right? You don't know you're going to enter into this kind of arena before. So I still think we're stuck at the starting blocks before even you think about how products will work. That's part of the thing. When you develop a product, you have to try and understand all these. You throw scenarios at it, right? And you try to understand how that would work in that particular situation if it was to arise. And that is probably one of the things that would be considered if there was demand in the first place, and then when you build that product, you'd think about that. I don't have the answer, and it probably doesn't answer your question as to how it works, but it's one of the things that would be considered.
I possibly have part of the answer. Most BT insurance, and a lot, well, number one, I think one of the early CFA validity cases did require the solicitors to check whether they had BT. I vaguely remember with alarm that we all changed our procedures overnight with forms to fill in and all sorts of, because I think, is that right, Rocco? Yeah, I can't remember what it was called. But
I think it was Sawar against Allen, but I'm looking at Mark now.
Yeah.
Yep.
So there was an alarming period where, we suddenly essentially made sure that we told every single client to check their legal expenses insurance, which I've always done ever since. The first requirement on any individual claim is that you have to convince your legal expenses insurer that your case has, I think it's normally more than 50% chance of success. And they won't pay anything until you do that. So you're still at the problem that Greg was talking about, the same litigants in person who are still in the court, even if they had litigation insurance, they would have had to do the same exercise on their own in order to convince their legal expenses insurers to pay. Now, what then happens is it's a bit like a steeplechase, so that you might get onto the first hurdle, but you have to keep reviewing that. So every time a letter or a defence or anything comes in, it's reassessed. And to answer Ray's point about how these people stay in business, is if they then end up making a payment because they've lost the case, they then have a negligence claim against their solicitors or barristers who've given the chances of success, and that's how they offload that risk. And one of the first PNLA members that we had was a partner in a firm doing that sort of professional negligence claim for a BT insurer.
Thank you. Ravi Nair from BCLP, and partly representing Professor Higgins and Adrian Zuckerman, who I've been writing a little bit with at the moment. Just by way of background, I've been involved in a few class actions over the last few years, but also have designed most of the, or been involved with the redress schemes for mass settlement of torts and what I suppose Gallanter would have called uneconomic claims. And just listening to the debate on BT insurance, it seems to me that the particular stimulus to make these changes is simply because we've got all of these uneconomic claims in these consumer class actions that need to be paid for. And let's be honest, both having defended them and also having produced them, you have to question who really benefits from these litigations. And I think that's just a general contextual point about the pricing of funding generally. We assume, I've got friends in this room that are funders, so I hope they won't mind me saying, but we've taken a view that there needs to be a certain return for funding. That's because the money comes from a certain place where there needs to be a return from the people that give the litigation funders money. So just starting from first principles, we're talking about consumer class actions, but really I would like to see the CJC really, and this goes to the last panel as well, pace more of a holistic solution to all of these problems. Obviously, we've spoken a lot about DBAs, we're speaking about insurance now. Really, we need to think about class action procedure, obviously particularly in the High Court, which has been rejected in the past. But it seems to me that if we have a better procedure for the mass settlement of consumer class actions and fundamentally uneconomic claims, we will be benefiting access to justice, but we won't need to create a situation where we have to have mandatory BTA insurance for all of the problems that have been suggested. So I would just really stress that the CJC should really consider all of these points together rather than look at them in a silo, which I may be stating the obvious, but that's just my perspective. Thank you.
Thank you. We've got a question from David at the back. And while we're getting the mic to David, and just on that last point, I mean, certainly my interpretation of the BTE issue is there are serious problems with it working on standalone claims. And I think in the first session, Jennifer Morrissey made the point that claims under £150,000 are very difficult to fund in any shape or form at the moment. And so if you can't make those standalone claims of, and these are not insignificant values, for the average man in the street, that is a lot of money. If you're struggling to fund those, actually trying to make BTE work for much more complicated consumer class actions is quite a big ask. And the logistics, I mean, if you tried to do that as an opt-in, the logistics of onboarding a whole group with all different insurance products, different exclusion clauses, different insurers would be terribly, terribly difficult. And then if you try and expand it out to opt-out claims, well, the sheer scale is an enormous challenge. But David, over to you.
Yeah, just a few practical points. First is that I think there is an education requirement that people should understand their household policy often has BT attached to it. But certainly as ex-president of the Law Society, I would say it's the professional duty of the solicitor on first instructions is to ask about BTE, because you're supposed to be asking about other methods of funding, how you're going to fund this. So you should be asking about BTE. We often use BTE as a seed for cases. Covers likely to be 25,000, 50, or maybe more than that is. So we might look at it for seed funding, just so that we can understand the case, get some ideas about it, because we may then do it on a CFA, but we can investigate it. And we use crowdfunding in a similar fashion. One of the difficulties we always have is, and we had this certainly at the Law Society, is persuading insurers to allow us to do the work. Because when you go to the insurers, they say, no, you've got to use the panel firm. And if you don't want to use the panel firm, then you must use the panel firm's rates. So that you often have that debate. And certainly in the Law Society, we were arguing with the insurers that you should have freedom of choice of your solicitor. And they were, we would certainly say they were restricting that because they would say, no, I won't allow you to have your choice. You're going to have to go to a panel solicitor. And you can see some logic to that. Is I think the difficulty with group litigation is that the insurer, to some extent, then loses control of the case because control is now in the group litigation, in the order, the lead solicitors, or in other classes. They've lost control of it. Whereas with their panel, of course, they've got a greater degree of control, both on reporting requirements, rates, all of those issues that I think will always be a difficulty. And there's always an exclusion, well, certainly my experience is an exclusion for group litigation or class actions or collective actions in those insurance policies. Compulsory, I think, is difficult, but I do think there's an education task to say to people is, well, you should be looking at your household policy and see if you've got some BTE cover, at least to provide some advice in advance of whatever you're going to do in the case.
If I can just come back on some of the comments that have come from the floor, a lot of which I agree with, I hasten to add. If we were to take the diesel emission cases, for example. And let's say you've got a group of 10,000 claimants and you're checking each and every one for BTE. How many of those would have BTE? That's the first point. How many could you get cover for? So, given where we are today, I think it's fair to say that BT could provide a solution in part, and there's always been an interplay between BT and other methods of funding. Always. Even going back to pre-Jackson, CFAs, ATE. And that continues to be the case. And Hilary made a fair point about, that you'll have one insurer for one client, one insurer for another, and then they react differently. And going back to David's point about the hourly rates that they're willing to pay, they've got their usual panel solicitors, they've got them on very lean rates, if I can put it like that. But if you were to extend BT cover for competition cases, which are currently excluded, you cannot have, and I don't want to be rude to any of the panel lawyers, but you're up against Freshfields. You cannot have one of those panel lawyers squaring up to Freshfields. It means then you have to pay significantly more in the way of hourly rates, which goes back to what I was saying earlier about that has to feed its way into the premium calculation. If you add this additional level of cover, it will come at a cost. And somewhere along the line, someone's got to pay it. And unfortunately, as soon as it gets more costly, the distribution becomes more difficult, which is why I go back to the employer, because employers want to give benefit in kind. They want to give value to their employees. But this is a tangled web. It's not a straightforward solution at all. And some very valid points have been made by the floor.
Thank you so much, Rocco. I'm conscious of time. We are at the end of our session. Did you have a quick point, Greg, you wanted to make?
I think group litigation is probably the one area that enjoys other funding models that BT just doesn't need to be there. And I have to say, everything you've said I found incredibly convincing. It seems to me any expedited rollout of BTE, so it's wider than it is, should probably exclude group claims for precisely the reason that you suggest. I think there are the particular areas where it can be particularly useful. You consider the number of cases in the employment tribunal where people are acting in person and haven't had access to advice. I'm sure the same is true in business property courts, boundary disputes, county courts. It's not the group actions that have the other funding models available. It's those. And even if it's just early stage advice, having more generalised availability of BT and people knowing that they have it, I agree with you. I think it's something that people don't foresee that they will need. They only realise on the far end. And it might be that the public needs to be convinced that they need it, and the insurers might, to borrow an Aaron Bevan's phrase, need to have their mouths stuffed with gold in order to provide it. But once it's in place, you can solve one particular problem that's a systemic one in the legal services industry, which is most of the lawyers we have are too expensive to take on a lot of the cases that we have, and nobody's finding a way to fund those cases. And that's a problem that has to be solved, even if group actions have their own solutions.
Greg, thank you very much. And thank you to all our panel in this session.
I've done it. Hello? Oh, that's better. Good. I wonder if we could just take our seats because we want to do justice to this last session. So just if we could, just 1 minute. Okay. Right, so the last panel session is on regulation. And if I could just introduce, please, Richard Orpin at the end, Director of Regulation and Policy at the Legal Services Board. Dr. Chris Decker in the middle, Research Fellow at this university and at HKA. And next to me, Richard Blann, who's Head of Litigation and Conduct Investigations at Lloyds Banking Group. So following the pattern of the previous sessions, I wonder if I could turn to Richard at the end to say a few words.
Thank you very much. Good afternoon. I'm Richard Orpin, Director of Regulation and Policy at the Legal Services Board, and for those of you who don't know us, we're the oversight regulator for legal services in England and Wales. So we're a statutory body created by the Legal Services Act 2007, and we're accountable to Parliament. Our primary role is to hold the frontline regulators to account, so the Solicitors Regulation Authority, the Bar Standards Board, and others. And we, along with the regulators we oversee, share a set of regulatory objectives, which include improving access to justice, protecting and promoting the interests of consumers, and promoting the public interest. In March 2024, we published a review of litigation funding in England and Wales, which was produced by Professor Rachel Mulheron, which found, among other things, that third-party litigation funding could help improve access to justice, but it was not a scalable solution, since litigation funders tend to choose a minority of cases available to them. And it also found that membership of the Association of Litigation Funders isn't the badge of honour that it was envisaged to be when it was established in 2011. Since then, we have observed that the expansion of third-party litigation funding has coincided with an increase in poor practice in some law firms in receipt of such funding, particularly in the high-volume consumer complaints sector, which has brought with it an increased risk of harm to consumers. And we're concerned that this pattern of behaviour puts the future of no-win, no-fee cases at risk and undermines trust and confidence in that particular part of the sector. We're concerned about poor standards of client care, conduct that puts short-term financial gain above the client interests and duty to the court, and other evidence of poor practice among law firms in receipt of such funding, such as a failure to properly assess the merits of the case and a failure to properly advise clients of their potential liability. We're also concerned about poor practice by some, admittedly not all, litigation funders, such as exerting undue control over the litigation process, attempting to obtain excessively high returns, or failing to meet capital adequacy requirements, particularly where funders make varied or risky investments. Now, in our view, this requires action from both legal services regulators and financial services regulators to address. On the former, and this requires no legislation from government at all, the frontline legal services regulators, and I have in mind the SRA in particular, need to be more proactive and effective in ensuring that law firms in receipt of litigation funding, particularly in the high-volume consumer complaints sector, comply with their obligations. And where that isn't the case, that the SRA takes prompt and effective action to protect consumers from harm. And we, as the oversight regulator, will hold them to account for doing so. On the latter, which of course is very much the subject of the CJC's review, we think there is a case for bringing third-party litigation funding within the remit of the Financial Conduct Authority in future to ensure that consumers are protected and do not suffer detriment as the result of poor practice. This would mean, clearly, moving away from the current voluntary model of regulation towards a mandatory model. And before I finish, I just want to address head-on the argument that such a step would be anti-economic growth or anti-competitive. On the contrary, we think that it would help support growth by providing a stable and predictable regulatory environment, and support competition too by providing a level playing field which doesn't currently exist in the voluntary model where not all litigation funders subscribe to membership. Thank you.
Thank you very much. Sorry, thank you very much. Chris.
Thank you very much, and thank you for the invitation to be on the panel. I'm not as close to this review as others in this room, so I'm going to offer some more general reflections based on my experience as someone who's worked on regulatory design and structures across many areas, someone who's worked on competition and regulatory matters, including before the CAT and other senior courts, someone who's worked on access to justice and the reform of legal services, and also someone who's an economist and will come with that perspective, focus on incentives and markets. So the first question was really, is there a need for regulation, and if so, what form should that take? That's a very common question, and that's a question that's been addressed across lots of sectors, and there's lots of guidelines on this. There's OECD guidelines, there's Cabinet Office guidelines, there's many guidelines. And I think there are several common principles you'll identify in these guidelines, which I think are very useful in responding to these questions. The first one is, the first one is the importance of defining the problem with some precision. What's the problem regulation's trying to address? A second point is taking account of the context in which regulation would be applied. And a third point is the importance of considering alternatives, including voluntary regulation, before introducing statutory regulation. So my remarks are structured around these 3 points. The first point about defining the problem with some precision. Well, what's the problem with third-party funding? I think just from looking at the consultation document, it wasn't immediately apparent. Rather, there are some potential problems there. There's some in-principle concerns. The consultation mentions on page 19 a need for regulation to protect from harm or unfairness and to some link to the national economy. But that's not really expanded on in any sense, and there's not a lot of evidence produced on that point. The trigger from reading the consultation document seems to be comments in the Jackson Review and the CJC consultation that if the market expands, then full statutory regulation should be considered. Just from reading the document itself, that seems to be the trigger for regulation. But I think if we step back and we ask ourselves, what is the overarching problem here? And it's been mentioned in the previous session. The overarching problem is unmet demand for legal services and legal needs. There are lots of concerning statistics about this, about legal issues that don't get pursued, let alone resolved. And in the previous session, we heard lots of issues about litigants in person. So the overarching problem is various frictions, blockages, and impediments that stop people pursuing legal problems. In economic terms, there seems to be a lot of demand to use the legal system, but there are problems on the supply side. That means that they never get pursued. So when you frame the problem in this way, the question then is there anything in the current regulatory arrangements that are restricting the ability of third-party funders to promote or facilitate access to justice? Could it do better in some way or another? So that's the first point, defining the problem. The second aspect when you're thinking about if there's a need for regulation is what's the context? And I think there are 3 important contextual factors here. The first is that the third-party funding market is a growing market, but it's not quite at maturity. It's arguably not yet stable. There's a lot of experimentation going on, new players, diverse business models. So a key question then is, what would be the impact of statutory regulation in this context? Would it promote or restrict growth of the market towards the goal that we're going towards? That's the first contextual factor. A second contextual factor is, arguably, third-party funding is a success story in some ways. I mean, if you look at the range of cases before the CAT, from digital markets to wastewater to transport communications, these cases simply would not be pursued or addressed by regulators or competition authorities. They just would never have happened. So in that sense, you could argue it's a success story. And the third contextual factor, and this is really important, is that it's a competitive market. So funders presumably compete by trying to differentiate themselves on various aspects, risk appetite, interactions with clients, etc. So when you're thinking about regulation of, say, business structures or capping returns, etc., you have to think very carefully about the context in which it's being applied. We're not talking about monopoly here, we're not talking about duopoly, we're talking about a situation where you've got many providers. And so there is really high risk in getting the thresholds wrong. It's quite a sort of blunt and arbitrary instrument if you introduce thresholds in some of these aspects. And I think the international survey in the consultation document highlighted that, where some of the returns were capped from 10% to 40% to 80%. That's a big difference. So if I turn briefly just to the second question, which is, if the current self-regulatory approach is maintained, does it need to be improved? Again, I'm not able to provide detailed comments on this question because I haven't seen the evidence on this, on any problems or limitations, and that's what's being gathered through this process, presumably. But perhaps I might comment briefly on general factors that contribute to the effectiveness of self-regulation and self-regulatory codes and rules. So what makes a self-regulatory arrangement work in various sectors? Well, there are a few things. One is wide participation in the development of any codes or rules. So you don't necessarily just want the industry, you want other stakeholders involved. You want a broad range of perspectives to be reflected in the regulations. And this can give a lot of balance and legitimacy to the rules. A second factor, an obvious factor, is that you want large numbers of suppliers participating in a self-regulatory arrangement. You want wide coverage to avoid any gaps, and you want to reduce the risk that there's free riding for those who don't participate in the rules, getting the benefit of the industry being seen to have a particular reputation. You want any diversity in the industry to be reflected in the self-regulatory codes. So if there's substantial diversity in the business models, for example, then perhaps separate codes or regulatory arrangements might be more appropriate rather than a one-size-fits-all approach. In some cases, you see self-regulatory arrangements having legislative backing. So they can be underpinned by framework legislation, which might set out a requirement to develop a code and standards, or might actually set out general principles for conduct, which are then elaborated in a self-regulatory code. So that's one option that you see. It goes without saying that effective self-regulatory arrangements have to be effectively monitored, and that they must be subject to monitoring arrangements. And in different ways this can occur. It can be undertaken by an independent body, it could be the sector itself, or it could be a state or designated regulator that monitors. Again, it goes without saying that enforcement of regulatory provisions within any self-regulatory code is very important as well. It gives legitimacy to self-regulation. And again, you see different approaches to that. The ability to vary rules and codes, that's another factor that's been seen to lead to very effective self-regulatory regimes. So if the codes can be varied and changed over time, that's something that leads to more effective arrangements. And finally, the ability to seek redress. So if the code is broken or in some way not complied with, then there's some way of resolving disputes. In many sectors, you see ombudsmen established, industry ombudsmen to resolve disputes. And these can be independent of the sector or established and run by a regulator. So they're my reflections on the question of whether a funding arrangement should be regulated, and if so, whether the self-regulatory arrangements are sufficient. Thank you.
Thank you very much indeed. And Richard, over to you.
Thank you. So I just wanted to say I come to this with the benefit of the input of a wider community of the in-house legal teams, and so who have sort of shared the wealth of real-world experience that we get as claimants and defendants in litigation throughout the country, supported on both sides by funding in some cases. And the reason we're interested in this is because third-party funding is a very imperfect way to approach access to justice, and a very inefficient method of delivering redress to affected consumers. And there's sort of fundamental inherent tensions between the interests of the funder, the lawyer, and the funded claimant. They're obviously aligned on the sort of broad objective you'd think, but the funder is not altruistic, apart from the people in the room, of course. And you don't get American hedge funds investing in litigation in the UK for the benefit of British consumers. What they're after is a return on investment. They're not interested in all claims. They say so themselves. It's a very small percentage of claims that get funded. They want to maximise the returns, and there's nothing wrong with that. We understand that, but it's important to recognise the realities of that dynamic. The lawyers, they want to secure an income stream and a bonus if they can. It's mitigated, of course, or it should be, by duties to the client. But in a claim that's created to maximise recoveries, these mass claimant claims, who is the client? There's a huge class of people who don't even know they've got a claim, don't even know they're involved in a claim. How does that work? the real relationship between the firm is with the funder, and that is again a feature that needs to be recognised when we're thinking about how this works. The claimants, if they care about the alleged harm at all, and I'm thinking about some of these actions in the CAT where the opt-out regime encourages claims where people wouldn't bring a claim if they were asked to, because they're only going to get £12 back or something for whatever it is. What do they want? They want to maximise redress, and redress isn't necessarily financial. For some people, that isn't necessarily what they want. They probably want to get it as quickly as possible, and they want it to be as stress-free as possible. And litigation may not be the best way to deliver that to them. So in this arrangement, the claimant is the weakest party, and within that dynamic, there's plenty of potential for consumer harm, and Richard was commenting on that. But this isn't theoretical. We have seen real-life examples where these risks do crystallise. And so the examples of the problems are things like the consumer getting very little information on the terms of the funding that's going to be provided to them. They're at the mercy of the solicitors who have a financial interest in the litigation going ahead and may not negotiate very hard because, as I mentioned before, the relationship is an ongoing relationship with the funder, which is their meal ticket. The claimant is exposed, or may be exposed, to adverse cost risks if things go wrong, and things do go wrong. We've seen some examples in the press quite recently where the lawyers collapse, the ATE won't respond, the funder doesn't step forward to pick up any liability, and so it's left with the consumer themselves. Another issue is settlement being taken out of their hands, their rights compromised without their consent. That is a feature of these mass claims. The claimants' interests are basically subordinate to the funders and the lawyers in the settlement waterfall because they're not there to negotiate it, and the class representative may not be particularly well equipped to deal with those negotiations, and we've seen some examples of that recently, I think, in the courts. And as always, with the things that come to court are tip of the iceberg, I think. And in any case, the claimants are going to lose out a significant proportion of any monies that actually come out of a settlement or a judgment. And there's as with all of this, the data is difficult to come by, but there is data from other jurisdictions which points to the sort of levels of percentages that are available through funded claims as against what people get through non-funded claims. Self-regulation is ineffective and inadequate. I mean, not all funders are signed up to the Association of Litigation Funders, and anyway, with the greatest respect, it has no teeth. What is the consequence of breaching the code? You get thrown out, but you can continue doing the same thing anyway. So regulation is required to protect consumers. We've got speculative commercial investors providing a financial service to consumers. So why wouldn't you regulate that? Other finance service providers have to be regulated. And what should the regulation cover? Well, things like capital adequacy, transparency to consumers. Marketing should be fair, clear, not misleading, that kind of basic stuff. They should have some kind of duties to detect and prevent money laundering. Where does this money come from? Nobody knows, or well, somebody knows, but it's not well known. There should be a cap on funder returns, or at least a floor to the returns available to claimants, so that the consumer actually benefits from the claim brought in their name, and suggest a duty to funded parties, much in the same way that financial services companies have a consumer duty, which again, acting to deliver good outcomes for retail customers, it's difficult to argue that that's not a good thing, I would think. Given the shadow role in litigation played by funders, I think it also needs control by the court, and that there are a sort of number of different elements to that, but you could think about amendments to the pre-action protocol to include a requirement to say if the claimant has explored alternative out-of-court redress mechanisms, that kind of thing. The fact of funding, the name of the funder should be disclosed at the outset of a claim, and there should be a presumption that security for costs will be ordered in funded claims, and rebuttable, but that should be the presumption. There we go.
Thank you very much. I think we can all agree those are magnificent contributions, but can I now open the floor? Yes. Sure, and you can have a microphone as well.
Thank you. I'm Rosie Hayes. I'm co-admin of the Legal Negligence and Mismanagement Campaign Group. Before I start, I'd like to address one thing. You're asking what the problem is. And the problem is not in this room. The problem, quite a few of us are watching online. There are only 2 consumers in this room who've experienced first-hand of litigation funding and litigation loan products. And it hasn't been good. So the problem is that there are no consumers in this room, apart from us 2, and we're here pretty much by chance. Because so many of the people with experience of this kind of financial product are watching online, could we please turn to some of their questions as well once I've finished, and I promise I'll be brief. So, there have been a number of claims made relating to the number of litigants in person that are caused by people who are not funded by litigation funding or litigation debt products. Actually, everybody that I know who's been funded by a litigation debt product has ended up a litigant in person far more quickly because of the high interest rates. So you end up running out of money much more quickly. If you're paying 33% on top of your legal fees, then you're going to run out of money far more quickly. Everyone in the divorce group, and there are some people who are being sold these on bereavement as well, has ended up a litigant in person. And some of those people have been litigant in person for many years, in fact. My divorce took 10 years because of the litigation loan. Not because of the divorce, but because of the funding. I have a couple of... Sorry, I'm going to have to read from here, and I'm shaking.
Don't worry, just take your time.
Okay, I have a few examples. So, and I'm just going to raise 2 points, which are examples of what's actually happened in real life to people provided with these forms of litigation funding debt. The recent resolution report on financial abuse in divorce estimated that, well, lawyers who fed into this report said that between £5,000 and £10,000 was being charged by law firms, family law firms, solely to administer the debt product, the litigation funding agreement. In my case, one firm of lawyers alone charged me £8,000 to set up a Novitas loan. Mr. Perslow here was a director of Novitas at the time. So £5,000 and £10,000 for administering a debt product. An independent financial advisor would charge you nowhere near that amount of money. These are not complex forms to fill in. They really aren't. All they were asking for was a valuation of your property, not a valuation, sorry, an estate agent marketing appraisal on the basis of which they would advance lending secured on half your home. And you can't sell half a home. So always there is a reliance on the compliance of the person that you're divorcing in the divorce loans. In addition to that, between £5,000 and £10,000 charged by the lawyers to administrate the loans before they've even started looking at your divorce, Novitas and other litigation lenders were charging £1,000 for administrating the loan. Now, in my case, and I know I wasn't the only one, I discovered that not only that, Novitas actually paid the solicitors directly on the date I signed my contract with Novitas, £575. And I know that I wasn't the only client who, where there was one of these fees applied. So my question is, if the solicitors are charging for administering the loan, and I'm paying them between £5,000 and £10,000 to do so, and I'm also paying the litigation funder £1,000 to administrate the loan, why is the litigation funder paying the solicitor £575 every time a client signs up for one of these loans? And how is that not a hidden commission? I'm not a lawyer, so I wouldn't know, but maybe it's something the very intelligent minds in this room could apply themselves to.
Okay, can I just, I'm not sure, I fully understand what you're saying.
I have just one more example.
Yeah, fair enough, but this session is on regulation and whether there should be, and if so, what.
This is about regulation, and this is why,
Okay.
this is one of the reasons why it desperately needs to be regulated.
Okay, all
So,
right.
anyway, moving swiftly on, one of the other claims that has been made in a previous meeting, the one on the 13th, was that these forms of litigation funding, these litigation loans, are that consumers receive the protections of the provisions of CONC. So the Consumer Credit Act and all of the various regulations that protect the consumer. I agree that some of these litigation loan firms that are selling to direct consumers via solicitors are protected by CONC, but there are also those that are not. So there's a law firm in the room that was selling rate-setter loans. Rate-setter loans were non-commercial loans. That's how they were non-commercial agreements. They were peer-to-peer loans, and they were not protected by the provisions of CONC. So if all of the people who are able to sell this form of funding want to claim that the consumer is protected by the provisions of CONC, then obviously regulation is urgently required, because some of these litigation funders, rate-setter being one, were selling products, or people were being referred to them for products which were completely devoid of all of the protections of the Consumer Credit Act and the protections of the provisions of CONC relating to affordable lending. This has happened.
Okay, if you don't mind, because we've got 9 minutes left for the session.
I finished pretty much.
But that's been extremely helpful.
that's
You're
it.
saying there should be regulation, and that's a point that I think is well heard. So thank you very much. Can I open the floor to anyone else? Yes.
My name is Alistair Kinley from Clyde & Co. Just really some questions and an observation. I think it seems to me that the issue here is the introduction of commercial non-recourse funds into the civil justice system. And if that's the issue, then I wonder, the scope of regulation is something that I think we really need to consider. Are we considering regulating the providers of those funds, or the agreements by which those funds are provided, or the use of those funds by lawyers and their clients to pursue the underlying claims? Now, all of those three options, I think, are potentially on the table. There may be more as well. And I'm not for a moment saying there should be a particular model of regulation, but I think the scope questions are absolutely critical. And I think they need to be defined in the further work that the working group does. And the observation is one from quite some time ago in the discussions around the CJC leading up to the sponsoring of the current self-regulatory code. And this is just a personal view. My impression from those discussions was that there was something of a standoff between the then FSA and the SRA, in that my take on it at the time was, this is not a legal service and it's not a financial service, so it sort of fell between the pair of those. That may well be where this review gets to, but I think the question needs to be front and centre of those making the decisions about the scope of this review.
Yeah. Thank you. Again, I think a point well heard. I don't know whether anyone wants to comment on it on the panel.
I'll just comment briefly. I think you hit on something really important there, which is about the boundary between financial services and legal services, and the fact that consumers don't live their lives based on boundaries that regulators occupy. So, the harms that we've heard about and that Rosie has spoken very powerfully about, I think should be addressed in that holistic way, where we think about what is the problem we're trying to fix and how can we ensure that legal services and financial services regulators work harmoniously and that have measures in place that are complementary to one another to ensure that consumers are protected, rather than coming at it from the other way around and perhaps missing the point.
Richard, in fact, I do have one question online, and I think it's probably one for you. You make the point that TPF should be regulated to protect consumers. Does the LSB, do you have a view about non-consumer situations, in other words, commercial or more general type of litigation?
Well, I think our starting point for this review has been the promotion and protection of the consumer interest. So that's certainly where we would come from. I suppose I feel on the non. I think this kind of goes to the point that we discussed perhaps in earlier sessions as well, where the funding has evolved and moved away from perhaps the original purposes to which some of this funding was intended, and now is directed at other cases where consumers are more impacted. So I don't feel particularly well placed to comment on the commercial aspect of it, but whatever we do, we should ensure whatever is put in place in future does adequately protect those consumers.
Yeah. Chris, Richard, do you want to say anything on that?
No, I just say yes, consumers should be the primary focus.
Yeah. Okay. Haven't got anything else online. Has anyone else in the room got any questions? Yes. For the microphone, just because everyone else can hear it then. Thank you.
Hello, Adrian Chopin, a managing director and founder of Benchmark Advisors, a litigation funder based in London. A great deal on which I would like to comment, but I'm going to keep my comments as brief as possible. I will leave aside the specific comments about divorce funding, consumer funding. That's a distinct market from the one in which I operate, which is commercial claim funding. So various comments were made, one of which was that litigation funding is not an altruistic business. I think unless Lloyds is operating as a charity, I think it's surprising that is raised as an objection. And the fact that Lloyds is not operating as a charity doesn't undermine the fact that it provides a valuable product. And I think the same must apply to litigation funding. The idea that funders may take too much control is already a regulated issue. Where a funder takes too much control, they may be liable to find their funding agreement held shamputers, which has draconian consequences, including that the entire agreement is held unenforceable. That appears to me already regulated. Waterfalls where funders take everything and claimants are at the bottom, I'm afraid that betrays a really gross level of ignorance of the current market, though that may once have been the case. Frankly, what has fixed that is competition. At the moment, I can't think of a time in the last 3 or 4 years where I've seen a waterfall where the funder takes everything at the top of the waterfall. Claimants and lawyers and other stakeholders already have a more beneficial position than was betrayed by that was suggested by that question. A presumption that costs be awarded as a potential solution, that is effectively the position. It may not be a position regulated in law. for my money, as a horrible red-blooded capitalist, not everything needs to be regulated by law. The position at the moment effectively is that any funder funding a case must expect that it will be held liable for costs if there's not ATE in place or insufficient ATE in place. Caps and floors on funder pricing. Two answers to this. The first one is that always and everywhere, in almost every market on earth, when you introduce price caps, the effect is a reduction in supply. I suspect that may be the intention of many of the people who militate for caps. The better response to what appears to be very high pricing would be to increase supply, i.e. let's make the market freer. That is one of the effects we have seen of the increase in supply of litigation funding over at least the 10 years that I've been in the market. Finally, even if some of these objections were cast iron valid, what's the alternative? What would we rather have? Would we rather not have these cases funded? Again, my suspicion is some of the objections, I don't level this accusation at any of the people on the panel, but some of the objections to litigation funding really are driven by a desire to see fewer funded cases. But if we're all acting in good faith, what would be our preference? Would we prefer not to see these cases funding? Is it not better that these claimants who receive funding obtain some redress, albeit with flaws, albeit with high costs, albeit with other drawbacks, than that they remain entirely unable to bring their case? In my submission, absolutely not. It's better that somebody receives some proportion of their claim, that they achieve at least the potential for access to justice, than not.
Okay, thank you very much. I'm not going to put that to the panel because what I'd like to do, focusing again on regulation, there is a question, and I should just say for the benefit of the online participants, there's a suggestion that some questions haven't been put. Focusing on regulation issue, I am putting all the questions that have appeared, and there haven't been many. But the one I would like, just very brief comments on from the panelists, please, is this question. Is there a risk of greater regulation encouraging defendants to mount collateral challenges to funded cases, or indeed a greater risk of disputes between the claimants and their solicitors? I wonder, it's a bit unfair, but we're running out of time. I think it's a good question, and I would ask for your views.
So personally, I think probably not. I think it might reduce the disputes because if the funders were regulated, you wouldn't have to go through everything that you go through at the moment trying to find out if they've got a funding agreement, have they got ATE cover, is it sufficient, have they got capital adequacy to cover, costs.
Yeah. Okay, thank you. Yeah, Chris.
Again, going back to my general points, it depends what the regulation looks like and the regulatory architecture looks like, and in particular, the problems that regulation is trying to address. And I think that's the key, the precision here.
Thank you. Richard.
I think I'd agree with the remarks already and just return to my fundamental point, which is I don't have answers to the specifics, but something needs to change, I think, from the current model, and we need to move away from the voluntary position that exists at the moment.
Okay, look, we have gone slightly over time. I'm going to have to wrap it up because people are traveling and so on. As I said, thank you everybody in the room, thank you the panelists, and thank you also the people who are sending questions through, which I've done my best to convey.
Thank you all very much. Haha. Thank you all very much for coming. Just before you disappear, knowing that trains are waiting, no doubt. I think we should just say thank you very much for Pembroke for hosting us today. It was very kind of them to offer the use of their building and facilities, so we should thank them. And also thank you all for coming, both here and those who attended online. We will take account of everything that has been said and all the questions that were raised both here and those that were sent in online as well in the considerations that we'll have following the close of the consultation process, which is next week. For those of you who haven't yet sent your submissions in, please do. We are waiting to read them with interest. I can see that we are going to be quite busy between now and the conclusion of the work that the Civil Justice Council has been given. I am hopeful, though, that we will do this over the next couple of months so that at least by the start of the summer, I hope that we will be able to report and that you will be able to see what we are recommending. Thank you all very much.